I want to tell you what I thought, not what I said, the moment that folder landed on the defense table. Because what I thought and what happened next are the two things that explain every minute of what followed. I have been on the federal bench for 26 years. Before that, 6 years teaching constitutional law to people who were going to spend their careers inside the same system I was about to ask them to trust. In that time, I have seen defendants arrive with every possible theory of their own innocence. I have seen genuine arguments. I have seen desperate ones. I have seen arguments that were neither, that were performances, constructed carefully from real materials assembled into a framework that the law does not recognize and has never recognized. The defendant walked in that morning carrying a manila folder the way someone carries a document they expect to be transformative. Not nervously, deliberately. The folder was thick, I could see that from the bench, and it had been organized with care. Tabs, color-coded tabs. The kind of preparation that takes months, not days. He set it on the defense table and he looked across at the plaintiff's representative, who was a younger attorney with a servicer who had done everything the law required and was now in that room asking the court to complete a process that the defendant's submission had interrupted. The defendant looked at the plaintiff's representative and smiled. Not the tight, anxious smile of someone who is not sure how the next hour is going to go. The confident smile of someone who believes they have already won. Who believes the folder contains the answer and that the only thing left is the formality of showing it to the room. I noted it, not for drama, for the record. I want to tell you what I thought, not what I said, the moment that folder landed on the defense table. Because what I thought and what happened next are the two things that explain every minute of what followed. I have been on the federal bench for 26 years. Before that, 6 years teaching constitutional law to people who were going to spend their careers inside the same system I was about to ask them to trust. In that time, I have seen defendants arrive with every possible theory of their own innocence. I have seen genuine arguments. I have seen desperate ones. I have seen arguments that were neither, that were performances, constructed carefully from real materials assembled into a framework that the law does not recognize and has never recognized. The defendant walked in that morning carrying a manila folder, the way someone carries a document they expect to be transformative. Not nervously, deliberately. The folder was thick. I could see that from the bench, and it had been organized with care. Tabs, color-coded tabs, the kind of preparation that takes months, not days. He set it on the defense table and he looked across at the plaintiff's representative, who was a younger attorney with a servicer who had done everything the law required and was now in that room asking the court to complete a process that the defendant's submission had interrupted. The defendant looked at the plaintiff's representative and smiled. Not the tight, anxious smile of someone who is not sure how the next hour is going to go. The confident smile of someone who believes they have already won, who believes the folder contains the answer, and that the only thing left is the formality of showing it to the room. I noted it, not for drama, for the record. I had seen this before. Not this person, but this specific posture, this particular arrangement of certainty. I have spent 26 years watching defendants walk into courtrooms with theories about why this court does not have jurisdiction over them, why the debt they owe is legally discharged, why the rules that govern everyone else in this building do not extend to them specifically. The theories change, the posture does not. There is a quality to it that I have come to recognize in the first 30 seconds, a quality of someone who believes they have found a door that everyone else missed, and who cannot quite contain their satisfaction about it. What was different about this case was the quality of the preparation. Most sovereign citizen filings I have encountered are thin. A paragraph asserting jurisdiction does not attach. A sentence claiming immunity. Sometimes a flag with a fringe on it mentioned in a motion, which tells me everything I need to know about the legal framework being invoked. This folder was not thin. This defendant had studied. He had found the relevant provisions of the Uniform Commercial Code. He had found case law, real case law, from real federal courts, that addressed questions adjacent to the ones he was raising. He had built an argument, not just recited a belief. That is what I want to tell you about before anything else happens in that room. Because the difference between a frivolous filing and a carefully constructed frivolous filing is not the outcome. The outcome is the same, but it is the thing that tells you the most about what you are dealing with. This was a person who had spent considerable time arriving at the wrong conclusion, and the wrong conclusion had been arrived at so thoroughly that he had convinced himself it was right. The debt was real. I want to establish that first because the rest of this will not make sense without it. The defendant had taken out a mortgage. He had made payments for several years. Then he had stopped. The servicer had followed the required notice procedures, every statutory requirement in sequence with documentation. They had sent the required notices. They had waited the required periods. They had done what the law asks of a creditor before it asked the court to step in. By the time this matter arrived on my docket, the servicer was not asking for anything extraordinary. They were asking the court to complete a process the law provides because the defendant had defaulted on an obligation he had voluntarily entered. The defendant's response to that process was the folder. Somewhere in the months between the default and that morning, this defendant had arrived at a theory. The theory had two parts. The first was that he could discharge the mortgage debt by tendering what the document called a bill of exchange, drawn on a treasury account in his own name, citing provisions of the Uniform Commercial Code, asserting that the creditor's failure to properly negotiate or dishonor this instrument within the statutory window meant the debt was extinguished. The second part was that even if the instrument argument failed, he was not subject to the court's jurisdiction at all, because he had filed documents asserting his status as a sovereign non-citizen national, exempt from the obligations that attach to ordinary United States citizenship. I had read both arguments before that morning. That is what the defendant did not know. He believed he was bringing something novel into that room, something the court would need time to untangle, something that would require a continuance, perhaps multiple hearings, time for briefing and response. What he did not know was that both arguments had been raised before, in this district and in districts across the country, and that the case law on both was not ambiguous. There was no circuit split. There was no unsettled question. There was a body of law that had addressed both arguments with consistency, and I had read it. I want to be precise about what that means for how I experienced the next 2 hours. It does not mean the hearing was perfunctory. It means I already knew where each road ended. The defendant was going to walk me down every road. I was going to let him. That is what the proceeding requires. Not because the outcome was in doubt, but because the record needs to show that each argument was considered and resolved on its merits. The defendant had a right to be heard. I heard him. And then I followed each argument to the place I already knew it would end. What I want to tell you about is the first argument, because the first argument is the one that tells you the most. The defendant's bill of exchange, the instrument he had tendered as satisfaction of the mortgage debt, was entered as his own exhibit. He was proud of it. He placed it before the court with the confidence of someone submitting a document they expect the room to receive with gravity. It was several pages. It was formatted to look like a legal instrument. It cited Article 3 of the Uniform Commercial Code with specificity. It referenced an account number. It bore what appeared to be an official header. The account number was the problem. Article 3 of the UCC does govern negotiable instruments. That part is correct. It governs checks, promissory notes, drafts, instruments drawn on real accounts held at real financial institutions. The provision the defendant was invoking, the provision that addresses what happens when a creditor fails to timely dishonor a presented instrument, is a real provision. It does real work in commercial law. What it requires as a threshold matter is that the instrument itself be a valid negotiable instrument, which requires that the instrument be drawn on an account that exists, at an institution that exists, holding funds that are real. The treasury account the defendant had referenced in his instrument does not exist. There is no mechanism by which a private citizen opens an account at the United States Treasury and draws instruments against it. The account number in the document was not traceable to any actual account at any actual financial institution. The instrument was not drawn on real funds. It was drawn on a fiction that someone had told this defendant was real, or that he had convinced himself was real, or that he had found described in a document online and had accepted without verification. I asked him about the account. He was ready for the question. He explained, with calm, with the patience of someone who has rehearsed, that the account exists by operation of law, that it is created at birth, that it is maintained by the federal government in connection with the bond that is issued in each citizen's name upon registration with the state. He cited the provision of the UCC he believed established this. He was precise. He was articulate. He had explained this before, probably many times, probably to people who had not known what to say in response. I knew what to say in response. Not because I am particularly clever, because I had read the case law. The account does not exist. The birth certificate bond theory, the treasury direct account theory, the straw man theory, these are variations on a belief system that has been litigated in federal courts for decades and has been rejected uniformly. There is no account. There are no birth certificate bonds being held by the federal government. There is no mechanism by which a private citizen has a treasury account against which they can draw instruments. The UCC provision the defendant cited requires an actual account at an actual institution. When you remove that predicate, when the account does not exist, the provision does not apply. You cannot trigger a dishonor provision with a document drawn on nothing. I said all of this on the record, not at length. The record does not require speeches, it requires clarity. I stated the predicate the provision requires. I stated that the predicate was not met. I stated that the instrument was not a valid negotiable instrument under the UCC or under any other applicable law. I sustained the servicer's objection. The defendant wrote something in the margin of a document while I spoke. I do not know what he wrote. He did not look up. He was moving to the next argument. The second argument was the jurisdictional one, and I want to spend time on it because it is the argument that revealed the most, not about the law, but about what this defendant believed about himself. The filing asserting sovereign non-citizen national status had been submitted to the court several weeks before the hearing. I had read it. It was lengthy. It cited the 14th Amendment. It argued that the 14th Amendment created a new class of citizen, the statutory federal citizen, and that a person born on American soil could choose to remain a national of the state of their birth rather than a citizen of the United States, and that in doing so, they would be exempt from the jurisdiction of federal courts and from obligations arising under federal law. The defendant had filed documents with the county recorder's office. He had sent notices to federal agencies. He had followed what he understood to be the correct procedure for establishing this status. I want to take this argument seriously before I tell you where it ends, because it is not a random assemblage of nonsense. It is an internally consistent theory that starts with a real event, the 14th Amendment, and builds from it a structure that requires only a few key factual premises to be true in order to work. The problem is that the key premises are not true. The 14th Amendment did not create two classes of citizenship with an opt-out provision. The ability to renounce United States citizenship exists. It is a real process codified in federal statute, requiring departure from the country, appearance before a consular officer, and a formal oath of renunciation. The defendant had not done any of this. He had filed papers with the county recorder and mailed notices to agencies that had no mechanism for processing them. He was a United States citizen. He had been one his entire life. Nothing he had filed had changed that. I asked him a direct question. I asked whether he had appeared before a consular officer to formally renounce his citizenship. He said he had not, because renunciation through the consular process is a procedure designed for the corporate citizen, not the natural man. I asked him whether he had departed the United States. He said he had not, because departure is not required for a national who remains within the territory of their nativity. I asked him whether he had any documentation from any federal agency acknowledging his claimed status. He had the notices he had mailed. He had the county recorder's filing. He did not have a response from any agency acknowledging the status he claimed because no such response exists, because no such status exists. The jurisdictional challenge was denied. The court had jurisdiction. He was a United States citizen subject to the laws of the United States and the state in which the mortgaged property was located. The mortgage was a valid and enforceable obligation. He was still taking notes. I want to tell you about the moment that told me the most about this case. More than the instrument argument, more than the jurisdiction argument, more than anything else in that folder. It came in the defendant's final submission. After the two main arguments had been heard and resolved, he raised one more. He pointed out that the servicer had sent him letters after receiving his instrument. 2 letters, administrative letters, the kind a large organization sends when it receives a document it does not know how to process, asking for clarification, acknowledging receipt. The defendant argued that these letters constituted acceptance of his instrument under the UCC, and that acceptance waived any defect in the instrument. This was his best argument. I want to say that plainly. It was the argument that required the most careful response because it touched on a real doctrine, acceptance under Article 3, that has genuine meaning in commercial law. Acceptance does modify the rights of parties to a negotiable instrument. Under certain circumstances, correspondence following presentment can constitute constructive acceptance. This was the argument that a skilled attorney would have sharpened into something genuinely difficult if there were something to sharpen it on. The same problem as every other argument in that folder, was the predicate. Acceptance under Article 3 requires presentment to the drawee. The drawee is the institution on which the instrument is drawn. The drawee here was the Treasury account the defendant had referenced. That account does not exist. You cannot present an instrument for acceptance to an entity that does not exist. Acceptance cannot occur. The provision does not become operative. The servicer's letters, whatever they said, however they were phrased, were administrative acknowledgments of receipt of a document the servicer had never encountered before. They were not acceptance. They were not close to acceptance. They were what any large organization produces when something lands in its mail that it has no category for. What I understood about this argument was that the defendant knew it was his strongest position. He raised it last. He developed it more carefully than the others. He cited specific correspondence dates and specific UCC provisions with the precision that told me he had worked on this one the longest. And what I felt watching him develop it was not the contempt that people sometimes expect a judge to feel in these situations. I felt something closer to the specific sadness of watching a person spend enormous effort in the wrong direction. He was intelligent. He had worked hard. He had built something that, from inside the framework he was using, was coherent and careful. The framework was wrong, not slightly wrong, fundamentally wrong, in ways that no amount of internal coherence could correct. The argument was denied. The servicer's letters did not constitute acceptance. The instrument was not a valid negotiable instrument and had not been properly presented, and therefore the acceptance provision could not be triggered. The record was complete. I granted the motion for summary judgment in favor of the servicer. I granted the foreclosure. I did it from the bench. I did not take it under advisement. I did not schedule additional briefing or a continued hearing. The record was complete and the law was clear, and the result was the only result the reasoning could reach. The folder had an answer for everything. It did not have an answer for the record. I want to tell you what the room felt like when I said that. The defendant did not react immediately. That is the detail I have carried. He was still. Not the stillness of shock. I have seen shock, and it is rarely still. This was the stillness of a person who is running a calculation they did not expect to need to run. He had been certain. The certainty was not performing now. It was processing. The plaintiff's representative gathered her documents. She had been in that room for nearly 2 hours, carrying the particular anxiety of watching someone attempt to legally erase what her client was legitimately owed. She did not look at the defendant. She looked at her notes, then at me, and she nodded once. The small professional nod of someone who has received a ruling they needed and will not make a display of it. I respected that. The defendant's folder stayed on the table for a moment after he stood to leave. He picked it up. He held it against his chest, the way people hold documents they have invested something in. I watched him walk to the door. He did not look back. I have thought about those 3 colors of highlighter many times since that morning. Yellow for the UCC citations, green for the Treasury account references, blue for what the document called the remedy. Someone had spent months building a case inside a framework that was going to collapse the moment it met the actual law. Not because the person was stupid, because the framework had been given to them, or they had found it, which is worse, and they had trusted it so completely that they had organized it in 3 colors and carried it into a federal courtroom. That is what I want to say to you about this case. Not about sovereign citizen ideology as a movement, not about the mortgage industry, not about the courts, about this, about what it costs to build a belief that the rules do not apply to you, and about what happens when the room designed to test that belief does its job without apology and without delay. The rules apply. The record is indifferent to what you believe about it. This is the thing I have come to understand across 26 years in that room. The thing that a morning like that one confirms. The record does not care how thick the folder is. It does not care how many colors you used or how many months you spent or how certain you felt walking through that door. The record looks at what the law says and at what the facts show. Every argument meets the record. Every argument ends where the record ends it. The defendant that morning walked in with absolute certainty about a conclusion that the record was built to test. The record tested it. 3 separate times with 3 separate arguments, the record answered the same way. Now, here is what I want to leave you with. And I am saying this specifically to anyone watching who is currently in a proceeding or waiting for one, or watching someone try to use paper to assert something they have no legal right to assert. The record is the thing, not the performance, not the folder, not the certainty of the person sitting across from you. What the record actually shows is what the ruling reflects. That has been true in every courtroom I have ever sat in. It was true that morning. It will be true in whatever room you are waiting for. If you have watched someone like this defendant, someone who believes they have found the door in the back of the building, the thing I want you to hold is this. The room was built to test exactly that belief. Not every room tests it quickly enough, and not every ruling arrives on the morning it should. But the record is honest in a way that certainty is not. The record does not negotiate with a belief. It answers it. I want to know if something in this case changed how you see something, about what courts actually do, about what the law says versus what someone has convinced you it says. Write it in the comments. Not a reaction, a specific thing. If this changed how you understand something you thought you already understood, make it real by saying it out loud. That is what this channel is for, and I read every single one. If what you heard today is the kind of account you have been looking for, the reasoning, not the headline, the record, not the summary, I would be glad to have you here. Subscribe, hit the bell. What I bring to this channel is the same thing I brought to that bench every morning for 32 years. The work, shown in full, with nothing left out. The folder stayed on the table for a moment after everyone had moved. I stepped down. The room was quiet in the way rooms are quiet when something has been resolved. Not a dramatic quiet, not a meaningful one. Just the ordinary quiet of a proceeding that went exactly where the record required it to go. That, too, is what justice sounds like. Most of the time, it sounds like that.